On June 15th, the U.S. Supreme Court issued a ruling in Bostock versus Clayton County, Georgia, saying that sex in federal anti-discrimination law included sexual orientation and gender identity. My guest today is Matt Sharp. He is senior counsel with Alliance Defending Freedom, a national alliance-building legal organization that advances the right of people to freely live out their faith. Matt, you are a friend to Nebraska Family Alliance and grateful to have you today in our discussion.
Always a pleasure to be on with you.
So, Matt, this case was a combination of three separate but related cases dealing with employment law and claims of discrimination under the Title VII of the Civil Rights Act of 1964. And basically, what did the Supreme Court rule? How do they define sex now?
What the court said is, although it's still cited to the idea that sex is biologically based male and female, it incorporated the idea that any differential treatment based on a person's sexual orientation or gender identity is a form of sex discrimination. So in some regard, the court sort of expanded what that term means, what sex discrimination means, to now include sexual orientation and gender identity. And so, for example, with Harris Funeral Home, which is the client ADF represented, it means that their sex-specific dress code, the requirement that men wear suits and women wear dresses as part of the way that they serve the grieving families that they work with at the funeral home, that you can't require a man to wear a suit anymore. If the man wants to wear a dress because of his gender identity, that you have to allow that. Otherwise, it is a form of sex discrimination. And so what we see here is the court expanding this to something that Congress never intended, that courts had never looked at, and to really redefine what sex means under federal law to now include sexual orientation and gender identity.
Give me your thoughts about, did the court overreach? Is this interpreting the law, or is this actually legislating the law?
I think Justice Alito was correct when he called this out as legislating from the bench. What the court is called to do is interpret the law, not to rewrite it or update it in light of modern preferences. And when Congress enacted Title VII in 1964, no one would have understood it or believed that it meant to incorporate gender identity into federal law. As the dissents pointed out, those concepts were barely even known at the time. And so what we saw here is the court taking a statute that everyone knew what it meant when it was passed, everyone knew what it had meant in the 60 years plus since then, but redefining it, rewriting it in light of these demands to expand it to include gender identity and sexual orientation.
So it's problematic in that it actually harms the potential to even free speech.
Yeah, when you take the court's reasoning is that any differential treatment is now a form of sex discrimination, it raises questions of, well, what does this mean for pronoun use in the workplace? Does this mean that employees can be forced to use inaccurate pronouns if one of their coworkers now identifies as a different sex than their biology says? Are employers required to learn all of the different ones, the Z's and the Zers, and the different pronouns that have been formulated by the gender identity movement? So there are a lot of questions about the impact on free speech for employers, for employees, and many others from this decision.
What are the potential harms to privacy and safety?
In the case, there was a lot of discussion leading up to it about what this could mean for separate showers, locker rooms, or restrooms, for women's shelters where you don't allow biological men to come in, and even sports teams. And what the court did, and we'll take the court at its word, was to say, we're not reaching the impact of all of those. We're not going to decide whether the ruling that sex now includes gender identity and sexual orientation means you can't have women's only restrooms or women's only sports teams or shelters or things like that. But we're already seeing activists taking this decision and starting to use it to try and challenge those very things. And what they're saying is, if you don't allow the man that thinks he's a woman to use the women's restroom or plan the women's sports team, you are now engaging in a type of quote-unquote sex discrimination under the Bostock ruling. So we're seeing the other side do exactly what a lot of us warned about when this case was being debated and heard by the Supreme Court of, is this going to impact privacy and safety? Again, the court said it's not going to rule on that yet, and we'll hold them to it, but there are already those pushing for it.
I'm assuming Alliance Defending Freedom sees multiple lawsuits in the forefront on this issue, and particularly in protecting religious freedom. Would that be a true statement?
Yes, absolutely. One of the questions is with religious employers of their ability to require all of their employees to live out the organization's beliefs about sexuality, about the nature of male and female. So we're going to be advocating for organizations like that to preserve their freedom to operate consistent with their faith.
Tell us about potential harms to religious organizations.
One of the most important freedoms of religious organizations is the ability to hire people that share their faith and to live out that faith. So whether it's a religious school that wants to make sure that its teachers, its workers, its staff all live out the same values that they're teaching to kids, or even a church and making sure that the church secretary or janitor knows the Christian values and lives them out. A religious organization needs to make sure that its employees and its people share that faith and live out that faith, or otherwise it really loses its impact and its ability to put the gospel out there. And so one of the concerns with this decision in Bostock is, how is this going to impact the ability of religious organizations, of a religious school or others, to make sure that all of their employees follow biblical teachings on marriage or on the nature of male and female, the ability to have dress codes and require men to dress as men and women as women, and follow other teachings on how we live our lives consistent with faith. And all of that is key to religious liberty, because if you can't require your employees to be religious, how can you really, truly, and authentically share and demonstrate the gospel to the world?
And such a good reminder to us, too, that our first freedoms is all about religious freedom. I know as people of faith, we can be very discouraged in a culture that's moving away from the timeless principles on human sexuality. As people of faith, what can we do?
I think two things. Number one, I think, is learning and showing people why these timeless principles are good, why they're best for society, and why we advocate for them, not because of hostility towards LGBT individuals, but because we think these are best for human flourishing, for relationships, for marriage, and for family. And so when we talk about God created us male and female, and that, males and females have God-given differences, and that when you unite those together in marriage, that they become greater than the sum of their parts and allow a way to raise up the next generation. So I think number one is just living out those values and those beliefs and showing the world why God's plan for us is best for all of us. But the second thing is, I would remind ourselves that God is still in control. He's still in control of the court and of our legislator and of our election and politics and all of this. And so many times we've seen in the past where there's been dark days or a decision we were all troubled about. And we've seen how in response there is often a push to capture back that which was lost. Even Justice Scalia had a bad decision years ago that resulted in the federal RFRA law. And so I give people hope to say there are still opportunities to make a difference, whether legislatively, whether in the courts and others, and we shouldn't view one loss as being the final nail in the coffin, but rather as an opportunity to continue to espouse those values and help pass laws to protect these timeless principles.
God bless you, Matt. I will say as we close out the week, a big amen. Thank you for the ministry of ADF and your role in legislative advocacy. We bless you, Matt.